Yes, everyone. In this video, I'm going to talk about incorporation by reference with regards to pleadings. Now, what is incorporation by reference, and why are we talking about it? Because it's a simple technique used by lawyers, solicitors, basically, which draft pleadings and contracts, and when they want to avoid repeating the same thing in their draft, in their pleading, or in the contract, they basically incorporate certain facts or certain statements that they have written somewhere else in their pleadings into a certain paragraph. Now that means that it's a handy technique to use. However, you should be aware of certain traps that you can fall into if you do not follow it. Correctly. Now, I will give you an example of what incorporation by reference is. Assume you are the plaintiff, and that in your statement of claim you are drafting misrepresentation. So you are alleging facts which constitute misrepresentation. That would be that the defendant stated the following representations which were false, and they were A, B, C, D, etc. accordingly. So you will state the representations. Now, in another paragraph, you will just say that the representations were wrong, or you can either do that in the same paragraph, stating that he stated the representation and that it was wrong because the truth of that fact was something else. And now assume that you want to assume that in another paragraph you're claiming, for example, negligence, or that you are claiming something else, such as a breach of fiduciary relationship, and that the same fact, those representations constitute the different cause of action that you want to claim under. One way of drafting the different cause of action is to mention the same old representations over again. However, you could also incorporate them by reference and save the effort and the time of drafting them once again, or copy and pasting them, whatever. And it's gonna make your pleading look a lot more compact. So under negligence, if one aspect of the negligence were those representations which were negligent, you could just incorporate them by reference. Now you can do that by stating that the plaintiff incorporates paragraph 8, for example, and states that the defendant acted negligently in acting as described in paragraph 8. Paragraph 8 being the paragraph which included the representations, the misrepresentations, basically. So, in this sense, the representations have been incorporated by reference. Now, you could also do that for different claims. For example, if there were different persons that made representations, or that repeated the same offense, that is more likely based on the majority of facts that you have stated for a different claim. For example, it may be a certain practice that was made though by a different person. So if everything just differs, if everything just is the same as if everything is the same regarding that practice, which gives rise to that cause of action or claim, and just the date and the persons that made it actually differ, then since you're dealing with allegations and not evidence, what you could do is simply incorporate the same old allegations, but just stating that with the exception that they were done on a different date and by the said persons, which were actually different. In this case, you will have also successfully incorporated a different claim, which was made on a different date or by different persons. What I'm saying is, it will be not it would not be productive to repeat, especially entire page sometimes, which constitutes a certain cause of action or claim. I'm using cause of action and claim because I'm using them interchangeably. Just because they give rise to another claim somewhere down somewhere in your pleadings. Now you have to be aware. You need to be aware because there are certain drafting techniques when you draft your pleadings, and if you have drafted, if you have, for example, incorporated by reference many previous paragraphs, and incorporated by reference stating that they constitute a certain cause of action or a certain claim, then in this sense, if they relate to a different person, then it's fine to incorporate the facts that relate to the person which was the primary character of the incorporated paragraph. However, if you want to reincorporate that paragraph, the one that incorporated certain paragraphs which belong to the facts belonging to another person, under basically a different claim, then this may be a bit tricky, because yes, you may incorporate certain facts, with the exception of a few points that only differ between the two paragraphs, the incorporating paragraph and the incorporated paragraph. However, if you reincorporate an already incorporated, reincorporate into a third paragraph, an already incorporating paragraph which has incorporated something different with only a few exceptions, then you're risking confusing your opponent over what you really mean, and what kind of exceptions he's going to have to take into account, and resorting himself to assumptions as to what would possibly apply to the reincorporated paragraph. So if you want to incorporate paragraph, you need to incorporate it in an intelligible language, in a simple language that's given effect to its incorporation. Because if it is messy, or if it contains a lot of cause of action at once, and a lot of evidence and relevant facts, if you try to incorporate that into different facts with slightly different exceptions or different cause of action, then again you risk the chance of confusing yourself, the judge, and the opposite party with what you really want to mean, and over what causes of action apply in the circumstances, and he will have to fill in the blanks of trying to see what is actually being incorporated. So thanks very much for watching. This is not legal advice, and please subscribe to my videos. I will see you all in my next video.